Members, it's the appointed time. We have a quorum. I call the meeting to order. We have the same papers. Welcome to the meeting. We also welcome the Secretary for Justice and the Secretary for Security and their team for joining this meeting. This is the 19th meeting. We continue to scrutinize Clause 113, and that will be in the reference table, item 14A. Members, let's continue to scrutinize the clause. Mr. Holden Chow. Now for Clause 113. 112 is about doxing. 113 is about intimidation. I have the same comment. Can we cover those handling or those who have handled national security cases or other people due to handling national security cases? Can we provide comprehensive protection for these personnel? And this is my comment for 112 as well. That's all from me. Ms. Carmen Khan, Chairman. Subclause 2. It's about the defense. Can the government tell us about the defense? Does that apply to just subsection 1D2? That is, 1A says that when something happens, inflicting harm, there is a defense. So can the government tell us the thinking behind this defense? Who would take the question, please? Mr. Ivan Leung. Thank you, Chairman. Ms. Khan is correct. The reasonable defense applies to only the second limb, and this means so when someone is performing a function or providing assistance. In Roman numeral 1, the intention is clear. It's to prevent or deter the specified person's performance of his or her functions, or the aider's provision of assistance in relation to the matter. There should not be a reasonable defense to this intent, but under Roman numeral 2, in consequence of, this subparagraph can cover cases where it's retaliation, so that's in consequence of something, but we cannot rule out cases where criminal liability arises. The wording is in consequence of, its cause and effect. We don't want Roman numeral 2 to get too broad in scope. That's why for this subparagraph, we provide a reasonable defense. If the action is reasonable, there is a defense available. Thank you, Chairman. No follow-up. Mr. Stanley Ng. Chairman. Clause 113 is very narrow in scope. It's very hard to convict someone based on Clause 113. Many conditions need to be met. 1A or B, C or D, they need to be taken together. All of them need to apply, and only then a conviction can be secured, and even then there is a reasonable defense. Clause 113 read together with Clause 112, you will see it's even harder to convict someone. You can say that certain claims are already online. Someone in the doxing group may label someone as a dictator, the public enemy, or a lapdog. Someone can say those claims, those remarks are already online, and the defense is available even on those grounds. So it's very hard to convict someone based on Clause 113. So I have a suggestion. Can we have a two-tiered system? A, B, C, and D, all of them apply, and then you impose a maximum term of 10 years in prison. But when it's just insulting the officers, there should be a lighter penalty so we can catch all those people. In that case, we don't have an unduly high threshold for conviction. Security Bureau, please. This is a policy question. Can we have a two-tiered system? We can give thought to that. Dr. Lo Wai-kwok. Thank you, Chairman. Clause 113, subclause 1, B and C. I see the connective and putting or in place of and would assure me. It's hard to prove C. How do you show something causes alarm or distress or specified harm to party B? In fact, we got an explanation from the officials yesterday, but can we have something more sensible? Can we make it B or C instead of having B and C? Secretary. Our legislative intent is this: causing alarm to party B. So an action has to cause alarm, and what does it mean by causing alarm to a reasonable person? So let's say someone talks while raising their voices and causes alarm. For a reasonable person, they don't see things that way, but everyone sees things differently. For a different person, someone raising their voices may be enough to cause alarm. So we have to apply a test of reasonableness. That's why the reference to a reasonable person is there, and that's in line with the legislative intent. I get the point about paragraph B. A reasonable person seeing that the act would cause alarm or distress to party B. That sounds objective enough. That's why I suggest B or C instead of B and C. But I note the Secretary's explanation. Mr. Tong Lin-che. It's important to safeguard national security. We have law to prevent people from doing improper things to endanger national security. We need to do everything we can to protect the family members of officers working on national security cases. So my question is, Clause 113, 1D, Roman numerals 1 and 2. Roman numeral 2. During the performance of duties or functions. So the officer continues to perform their functions. Is that a continuous process? Or does that refer to a past in which an officer performed such functions? So my question is, why emphasize the process during which something is done? 1 and 2. We're talking about two different scenarios. So the action has not started, or someone is about to perform certain functions. But another person comes along doing something to deter the first person from performing the functions. Now, Roman numeral 2. The officer is already performing the functions, but another person does something to deter the officer from performing the functions. So there's a difference in the point in time. But for Roman numerals 1 and 2, these two cases refer to attempts to harass an officer at different point in time as the officer performs or is about to perform a function. So Roman numeral 1 means an officer will or is about or has already performed the function. You're trying to clarify the point. That's why you have Roman numeral 2 specifying an officer performing in the process of performing a function. Now, it refers to any part of the process in which an officer performs a function. We want to cover everything. Why not draft it in a simple way? Just say that when the officer performs a function, and it doesn't matter whether the officer is about to perform or is already processing or will perform such functions. Chairman, my impression is that, as Mr. Stanley said, it's hard to reach all those thresholds under Clause 113. It's imperative and necessary for us to protect persons handling national security work, but why set so high a threshold to convict those trying to harass these officers? DS, please. I can invite my colleagues from the Legal Drafting Division to supplement my response in a moment, but D2 refers to two different scenarios. Some refer to specified persons, others refer to the aiders. The drafting, as it stands, is not trying to create a new threshold. The provisions are there to clarify things. Any response, supplement from the LDD? Mr. Vernon Long. Oh, sorry, it's the Secretary for Justice. We are not narrowing things, but instead broadening things. When you read the Chinese and the English text together, you will get a clear picture. Now, harassing or intimidating someone. Say you have an enforcement officer. The officer is about to perform their functions or has performed the functions, a thing done or attempted to be done by the specific person. This covers a broad range of measures. An officer is about to prosecute someone, and someone else tries to intimidate this person, that's covered, or a prosecution is ongoing and intimidation comes, that's covered, or the work is done and someone comes along to intimidate the officer, that's also covered. So the drafting as it stands is all encompassing. The officer performs functions about national security work. It doesn't matter if the officer is about to perform the functions, in the process of performing the functions, or after performing the functions. Any intimidation that happens during any point in time will be covered by this clause under subclause D. So as you said, it covers before, during, and after the work is done. The English text is clear: a thing done or attempts to be done. Next, Dr. Kennedy Wong.
Thank you, Chairman. Clause 113. Subclause 1A, Roman numeral 1. The focus is on communication. Yet, every day, in your email inbox and via telephone, there are lots of scam messages. And also on social media platforms. Many of these scam messages are sent from places outside Hong Kong. Clause 113 does not carry an extraterritorial effect. So will that undermine the deterrence effect of Clause 113? And in the process of law enforcement, well, let's say the offender holds a telephone number from outside Hong Kong, and the person is outside Hong Kong. So would that undermine the evidence gathering of the law enforcement agency? Secretary. Dr. Wong is right. The clause does not carry an extraterritorial effect. We are targeting actions done in Hong Kong. The point is to address the harassment of persons handling cases or work concerning national security in Hong Kong. So whether the telephone card is issued in Hong Kong or outside Hong Kong doesn't matter. As long as the offender is in Hong Kong when the act is committed, then the clause can cover the act. Even if the telephone card is issued by a telecommunication network outside Hong Kong, the person is using our local network in sending the message. Mr. Leung, if the message is sent from abroad and is received by a specified person in Hong Kong, then part of the act occurs in Hong Kong and Hong Kong courts will have jurisdiction over the case. Next, Ms. Carmen Kan, second round. Chairman. Concerning the legislative intent of the clause, I agree with Mr. Tong Lijie. The purpose is to protect persons with the mission to safeguard national security, and also the aiders, that is, the people who assist in evidence gathering of national security cases. Protection is the key. We want to enhance the protection for these two groups of people. So I appreciate the clarification about the scope. You don't need to present evidence like medical reports to prove alarm or distress. As long as the person feels alarmed or distressed, even if the offender claims that this is not an act which would cause alarm, according to the reasonable man test, it would cover. So I think Part C is fair. We would adopt the reasonable test on both parties' action. According to the administration's explanation, as long as the receiving party feels that they are harmed, so the threshold is not very high. So I want to put that on record. Concerning extraterritorial effects, I sincerely hope the administration would consider adding the effect to the clause. Like the previous clause in doxing, the extraterritorial effect would apply only on Hong Kong residents and organizations overseas. We see a lot of online bullying and harassment, and many of these acts are committed outside Hong Kong. Causing alarm or harm to specified officers and aiders. Now, specified harm includes both physical and psychological harm. So we should consider threatening or harassing or messages of harassment sent from abroad Hong Kong, because the effect on a person's mentality would be the same, Secretary. I believe that if an offender sent such a message to a specified officer in Hong Kong, and parts of the act would occur in Hong Kong, and Hong Kong courts would have the jurisdiction to deal with the case. So why do we need Clause 112, Subclause 3, if your explanation is right? Subclause 3, for doxing, part of the act, the reception of the message takes place in Hong Kong. So I don't think it is right not to apply extraterritorial effects to Clause 113. Even for doxing, no matter where the sender is, as long as the message is received in Hong Kong, then it should count. So it doesn't need extraterritorial effect either. So the protection for specified officers and aides stem from Clause 112 and 113. I don't understand why there is a difference in terms of extraterritorial effect. DOJ, Mr. Low. Thank you, Chairman, and thank you, Ms. Khan. Since you mentioned Clause 112, we explicitly applied extraterritorial effect to Clause 112. Now, we are targeting disclosure of personal information. It might not have a direct connection with our jurisdiction. That happens entirely in an overseas jurisdiction. Now, for harassment, part of the act would naturally take place in Hong Kong, because the specified officers are in Hong Kong, and then the Hong Kong courts will have jurisdiction. It doesn't involve the matter of extraterritorial jurisdiction. So there is a cross-boundary element for mere disclosure of personal information, that is disclosing personal information without the consent of the subject. It happens entirely within a single jurisdiction, so we need an extraterritorial effect to the clause. Now it is my turn. Maybe Mr. Leung can answer my question. I don't have time to conduct my own research on this subject. For the so-called grievous bodily harm, GBH and AOABH, assault occasioning actual bodily harm, can you tell me the comparison between the punishments for these offences? For AOABH, the maximum penalty is 3 years imprisonment. For grievous or wounding with intent, that carries a life imprisonment sentence. Now for specified harm, in terms of property, worry, or psychological harm, you haven't mentioned a physical and bodily harm, so I just want to compare the punishments for the offences. Why not include bodily harm under the clause? If it is more than a threat, if there are actual criminal acts, how would that be dealt with? I know you can resort to AOABH or wounding with intent to charge the person, but the punishment is lower for AOABH. Under this clause, the maximum sentence is 10 years. For wounding, on the other hand, it carries a life sentence. Is that your reason for not including bodily harm in the definition of specified harm? Let's look at the nature of the offense. The focus is on harassment. Naturally, that is applying psychological stress to the specified officers, that is causing alarm to the officers. The focus is not on actual bodily harm. As you mentioned, Chairman, if an actual act is done to a specified officer in retaliation, then we would deal with it with the ordinary bodily harm offences. Mr. Tommy Cheung, Chairman. Subclause 1B. The reasonable person test applies. Subclause 2, the defense. The phrase is to establish that it was reasonable in these circumstances. Now, during a social turmoil, people in society may have very different interpretation on what is reasonable in these circumstances. So the reasonable test in subclause 1B and the reasonable in these circumstances test in subclause 2, how do they compare with each other? Who should set the bar? Which official? Allow me to attempt this question, and I will invite my team to supplement. When we say reasonable, it depends on the situation. The context is important. We have to consider the context, and we can't apply the same yardstick in every case. Ms. Wong, Law Drafting Division. Thank you. Subclause 1B, that is a reasonable person. Subclause 2, the scenario, reasonable in these circumstances. So both focuses are on reasonable. It's just a different use of phrase. Mr. Low, let me explain why we say reasonable in both subclauses. Subclause 1B, it means whether a reasonable person would feel alarmed. Subclause 2, the defense, refers to the person committing the act of harassment, whether the action itself is reasonable. So the subjects are different. Now my question is, during social turmoil, if you put yourself in the situation back in 2019 and 2014, the test of reasonableness in these circumstances would be very different from now. So how do we decide if it is reasonable under these circumstances? Secretary, allow me. The word reasonable in the legal context is a very common word, whether in criminal or civil proceedings. The point is to look at the facts objectively. Of course, the details vary case by case, but like Mr. Tommy Cheung said, if the context is a very turmoil situation, that's a consideration we would take. And different people will have different understanding on what is reasonable. So the judge will consider all factors, including local and international situations at the material time and also the parties involved. So time, place, and parties. The courts, the judges in Hong Kong are experienced in considering a comprehensive list of factors. So this is the training for our judges.
Mr. Gary Chen, Clause 113 is there to protect people working on national security cases. As other members have said, the prosecution threshold is very high. Let's look at 113, paragraph C. The words communication or act in fact causes alarm or distress or specified harm to party B. Alarm, distress, or harm. Let me give you an example. The Secretary for Justice and Secretary for Security. You have seen many things. Someone tries to intimidate you, but you are unfazed, so it would be very hard to convict that person. If people can recall, there was an electrical member from an opposition camp hurled a mug at the chief executive. That member was charged with common assault. At the court, that former electrical member explained the chief executive appeared calm, undisturbed. That became a defense. When you make causing alarm or distress the threshold for conviction, that threshold is too high. Will that defeat the purpose of Clause 113? Secretary Bureau, Security Bureau. That's why there is both a subjective and an objective element. So, say someone has raised his voice. The average person may be alarmed, but I am unfazed. In that case, that may not be what we are trying to target because that action does not achieve the purpose of alarming me. That's why we need both a subjective and an objective element in harassment or intimidation. Our legislative intent is to target an action with the intent that actually causes harassment. We used to have just criminal intimidation to deal with that, but not every case reaches the threshold of criminal intimidation. And for criminal intimidation, the highest penalty is just 5 years, but the maximum penalty here is 10 years. That's what we're trying to target. Mr. Chen Xiuhong speaking for the second round. Thank you, Chairman. I raised a question about Clause 113 yesterday. Unlawful harassment, subclause 1, A, B, C, and D, all of them need to be met before we can prosecute and convict someone. It's a very narrow scope, so I suggested something. Now, we also have subclauses 2 and 3. There is a statutory defense. The government will have to prove the offense, and it will be hard to actually convict someone. Clause 113 is about people handling national security cases. This covers investigation and lawful performance of functions, and someone comes along to unlawfully harass the officers. Clause 113, subclause 1A, B, and C are conclusive proof of causing harm or alarm to Party B. Those are already enough in ordinary criminal cases. Now there is also the paragraph D. Because under D, this is about harassment targeting people working on national security cases. D should be a reason for stiffer penalties. I don't quite get the government's explanation. Clauses 1 and 2 are about the intent to impede or obstruct national security work. And the harassment happens while a specified person is performing their functions. And then the Roman numeral 2, there's also a defense, or rather subclause 2. What's the thinking behind the defense? We looked at clause 112 yesterday. That clause is about doxing. There is no defense for doxing. So the question for 113 is why have so narrow a scope? Say Party A meets conditions A, B, and C under clause 113, and there's also condition D, harassment targeting someone working on national security work or an aider. I don't see the need for a defense. Sorry, can you get to your question? Your time is almost up. Can we disapply the defense in that case? Who will take the question, please? Mr. Vernon Low. Mr. Low. Thank you, Chairman. I thank Mr. Chen for his question. We don't have a generic offense of harassment. So people may not be familiar with the offense of harassment. Creating a new offense of harassment would warrant caution. That's why in drafting this provision, we want to set out the appropriate conditions to assure the public that they won't get caught by the provisions here easily, while at the same time we can safeguard national security. In drafting the provision, we have looked at overseas examples. In Singapore, there's the Protection from Harassment Act 2024, Section 6. The Singaporean law has a similar offense. There, they also have a statutory defense. If the court finds the defendant's action reasonable, there is a defense. So we have looked at that example and made reference to that. It's not enough for the person, the defendant, to find their own action reasonable. The court will look at all the circumstances and also have due regard to the safety of officers working on national security cases to determine whether a defendant's action is reasonable. Sorry, Mr. Chen, your time is up. Please wait for your third round. Dr. Lu Wai-kwok speaking for the second round. Thank you, Chairman. The worry from me and other members is that we're too lenient to enemies while we're being too stringent to those helping us. One C causes alarm, distress, or specified harm to Party B. Let's look at our Secretary for Security. He's a tough man. We all want to keep our country safe. We are not afraid of harassment. We are unfazed. So harassment will do little harm to us. But then let's think for a second. Even if the person you target remains unfazed and unharmed, say it's online scam, just because the would-be victim does not fall for the trap, that doesn't excuse the scammer. And that certainly does not mean the scammer can go scot-free. We're talking about unlawful harassment of people handling cases working on national security. It's unlawful harassment. But the threshold for proof is high. And the defense creates the impression that it can be invoked easily. So we're being too lenient to potential perpetrators while we're being too strict and stringent towards people helping us. In 2019, my family members and I were harassed, so I guess I'm in a position to comment on this matter. A comment would do nothing to intimidate me. Someone may call the office of my family member. That's a different scenario. Then I will use a different yardstick to determine what's reasonable. What's reasonable depends on the time, the place, the people. We're not talking about leniency. We're trying to be fair. Justice has to be fair. It's not about compassion, leniency, or mercy. It's about potency and fairness. In some cases, someone shouts, and that may be unreasonable. That would be harassment. Say you have a setting. It's a crowded, it's a noisy environment. Passions run high, people talk in a loud way. In a different context, an otherwise unreasonable action may become actionable, and it's vice versa in a different context. So we have to take a fair view. Let's look at the intention and whether the person has achieved the purpose of intimidating someone and whether the other person is alarmed. So we believe we have laid down fair criteria. And we are offering suitable protection for people working on national security cases. At the same time, we also ensure that people without the criminal intent will not get caught inadvertently. Mr. Jeffrey Lam. Yesterday, I commented on Clause 113. On the question of whether the person feels alarmed, it's hard to prove. The Secretary for Security used to be the Commissioner of Police. I know he's a tough guy. We can see that. In 2019, Mr. Chris Tang visited the district without wearing protective gear. He was unfazed. But Mr. Tang also has a wife. His wife may be alarmed. His wife may tell the Secretary, Chris, take care, be careful. So Mr. Tang may be worried when he's performing his duties. Family members may be worried. I know Mr. Tang's wife is very good at what she does, but then she may be harassed. She may have to keep looking over her shoulder. The impact may extend to Mr. Tang's entire family and his friends. But then others will say, Mr. Tang is unfazed. I don't see how I have harassed him. We have to consider this scenario. The harm may be long-lasting. The harm may last for a lifetime, and you may experience sleep loss. So what to do? We have to consider how you can prove someone feels alarm. That's my comment. Secretary, you can ask the person whether they are intimidated or alarmed. So that should be easy to prove, and that is whether this person is alarmed. Just then, Mr. Jeffrey Lam mentioned the feelings of family members. That's why we cover family members in this clause. In the past, the protection would cover just the officer, but now this bill will cover family members because in 2019, many officers saw their family members harassed. But I'm saying the family members were affected despite not being directly harassed. This is something for the government to consider. That's Mr. Lam's suggestion. Please consider. Reverend Peter Kuhn speaking for the first round. I don't have any issue with reasonableness, but I have a question. Insulting is not an offense under our existing law. Now, when an officer is handling a case, a specified person can cover a lawyer or other people. National security matters need to be kept secret. A lawyer may be working on a case. How can people tell when a lawyer or other people are working on national security cases? So when you try to scold someone working on national security cases, this may fall under Clause 113. But when that person is not handling national security work, then this scenario will not fall under Clause 113. So the question is, how can people tell when someone is handling national security cases? Because that has an implication on whether Clause 113 applies. Deputy Secretary. Now we're talking about officers who make public appearances. They investigate a case or they appear at the court. These are officers whose identity is made public, so people can recognize those officers. So we're talking about people whose identity, that is, officers whose identity is already made public.
Another question. Say a case is closed and the barrister has been involved in the case, and after the case, the barrister is still remembered for taking part in a certain case by the public. So I just want to clarify the scenario. Under our existing law, you can scold the barrister however you want, but I want to understand what scenarios do Clause 113 cover. Allow me, this is a legal matter. Reverend Peter Kuhn's question explains why we need subclause 1D. That is the effect and the reason for doing so. If the intent is if there is no criminal intent, then one would be guiltless. So you have to prove the cause and consequence. Now, let's say if you were involved in a case 10 years ago and I threaten you 10 years after, it would be harder to prove the intent. But on the other hand, if you just walk out from the courtroom and I threaten you, then the intent is easier to prove. Mr. Holden Chow, second round. Thank you, Chairman. Let me give you a reference. If you refer to the doxing offense under the personal data privacy ordinance, there is a two-tier offense under the doxing offense. If there is a specified harm, if there is proven specified harm, the punishment would be heavier. If not, the punishment would be lighter. So there are a two-tier punishment for the doxing offense under that ordinance. Now, during the Black Lives Violence, I was the chairman of the panel on constitutional affairs. Our members questioned whether we can prove the harm. Some we can, some we cannot, but we still want to protect those officers whose harm we cannot prove. So under that section, there are a two-tier mechanism. There are two punishments for different tiers of offenses. So for Clause 113, we have discussed it quite extensively on the specified harm and whether it can be proven. So can we apply the same two-tier system? If the specified harm cannot be proven, then the maximum sentence should be lighter, say 5 years. If specified harm can be proven, then 10 years. A two-tier mechanism might be able to address our concerns while deterring the offenders. So that's my suggestion for the government. Thank you. That's a view. Mr. Tommy Zhang, second round. Chairman, I believe the answer is clear. Subclause 2. If you look at the English text, it is a defense for the person to establish that it was reasonable in the circumstances to use the words, make the communication, or do the act. So when a person put up the defense, they can subjectively say that this is a reasonable circumstance. I find it too broad and too lenient. According to Mr. Low just now, the accused can put up such a defense. Whether the defense is accepted or not depend on the judge's objective consideration on whether the defense is reasonable. So it seems very broad and loose, but we rely on the judge to make a decision. So my first impression is that the defense is too loosely defined. One may subjectively claim that the situation is reasonable. So having heard the government, I think there is a safeguard and it is not too loose. Is my understanding correct? Let me give you another example to explain the test of reasonableness. Let's say if a person hurled insults on an officer, but that person turns out to be a rude person who talks in the same way to his daughter. So we have to put all the elements into context. The person isn't hurling abuses at the officers deliberately. That's just how he is. So that's the reasonableness test I'm talking about. There being no further question, together we have spent 1 hour and 15 minutes on scrutinizing clause 113. So I think discussion is concluded. So now we move on to clause 114. Thank you, Chairman. Clause 114, enactments amended. The enactments specified in divisions 2 to 29 are amended as set out in those divisions. Thank you. Any question? Please move on. We've now come to clause 115. Or clause 123 concerning pension, gratuity or allowance cancelled, suspended or reduced on conviction. Now clause 123, section 15, pensions of pensions ordinance amended. Pension, gratuity or allowance may be cancelled, suspended or reduced on conviction, etc. Section 15 sets out certain circumstances where pension may not be granted to the recipient. Now, A brackets 3, the original reference is treason under Section 2 of the Crimes Ordinance Cap 200. We will substitute the phrase with any offence endangering national security. Thank you, Chairman. Mr. Kissen-Yang. Thank you, Chairman. I support the idea that those who are convicted of the Safeguarding National Security Ordinance should be deprived of their pension. Now, pension, gratuity, or allowance. What about civil servants' pension? Is that covered? Second question, it may seem unrelated to this clause. What about CSSA, old age living allowance, and higher old age living allowance? For a person convicted of the offense, should those be stripped from them as well? I don't think under this clause because this is about pension. What about allowances? Will they be asked to cough up the allowances they received during the material time? Deputy Secretary, please. Thank you. We introduced the amendments because in Article 35 of the Hong Kong NSL, there is a provision that for a person who has been convicted of a national security offense and is sentenced by the court, they would be disqualified from standing as a candidate for relative government positions. So we are applying that concept in the context of pension. The original reference is treason under Section 2 of the Crimes Ordinance. We think we have to update the reference to any offense endangering national security. Concerning the scenario mentioned by Mr. Kissen-Yang, it seems unrelated to the scope mentioned in Article 35 of the HKNSL. So it might not be the appropriate forum to discuss that. Mr. Kissen-Yang? Of course, old age living allowance and CSSA are not covered by this clause. I understand this. But I don't think these are mentioned in any parts of the bill. So this is my own view. Maybe the government should consider suspending or taking away those benefits from the convicted as well. So the civil servant's pension, you haven't answered me. Is that covered? A view and a question. We take note of your view, and for the question, you are right. We refer to the pension of civil servant as well. Mr. Jeffrey Lam. Chairman, upon retirement of public officers, they enjoy a pension. They can choose to take the bulk of it in one go, or even it out throughout a period of time. So what if the person chooses to take all the pension in one go? Can we claw back the pension taken? And how can we ensure fairness? Deputy Secretary, well, concerning the unparalleled situation, I don't think we can address that under this clause. What we seek to address in this clause is to ensure that the undisbursed pension being disbursed to the person. For the part which has been disbursed to the civil servants, after conviction of a national security offense, it seems that there is no redress to that part. If not this bill, what about other mechanism? Is there another ordinance which can deal with that? A public officer is retired. So can we specify that upon conviction of so-and-so offense, even if you have chosen to receive the pension in one go, that can still be dealt with? Mr. Chris Tang, okay, I'm a pensioner. I will be a pensioner after retirement. So I can only choose to take the bulk of it or a minority part of it. I'm talking about the older civil servants who are eligible for pension. So I will get a disbursement every month. So if I'm convicted, of course, I won't get the monthly disbursement. And upon retirement, you can choose to get the bulk of your benefits. So for the part that I've spent on, say, buying a house or given to my family, well, if I claw back those parts, my family members may have to apply for bankruptcy. So we are seeking only to address the part which has not been disbursed yet. Dr. Kennedy Wong. Clause 114. Or clause 141. The reference, treason under Section 2 of the Crimes Ordinance, is substituted by any offense endangering national security. Now we are changing the offense, say, any other offense to any offense endangering national security. So why don't we make it clearer that an offense under the Safeguarding National Security Ordinance and the Hong Kong NSL? Now concerning the phrase any offense endangering national security, I think the lightest offense only carry 1 year imprisonment or 2 year imprisonment. So if a person is convicted of these minor offenses, is it fair to strip them of their pension, gratuity, or allowance? Deputy Secretary, concerning the reference offense endangering national security, we have defined the term in the bill, so the scope is clear. That is clause 7 of the bill. Concerning the reduction, there is a reduction mechanism. The Civil Service Bureau will look at the nature of the offense endangering national security and impose the appropriate punishment.
Thank you. Mr. Tony Tse. Thank you, Chairman. I was going to raise a question, but the Deputy Secretary has already answered that question I had in mind. The wording here is about breach of any or committing of any offense endangering national security. The benefit, or rather the pension gratuity allowance, may be cancelled, suspended, or reduced. So just to further clarify, it depends on the gravity of the offense. And then it's not the court that decides whether to cancel or suspend the payment. It's the Civil Service Bureau that will act in accordance with the mechanism and then decide on what to do. That's why it said may be cancelled instead of must be cancelled. So am I reading that right? Is that what it says? Yes, correct. Referent Peter Kun. Other members have asked the question I have in mind, so I have no further questions. Mr. Tommy Cheung. Chairman, can I clarify a point? As far as I know, civil servants' pension can be withheld while the civil servant is on the job and commits an offense. But after a civil servant retires and commits an offense, the civil servant's pension has to be paid all the same. So if this clause comes into effect when a civil servant commits a national security offense, the pension can be withheld in part or in full. So my question is it a case? I think for civil servants, the pension cannot be reduced or cancelled now, but the clause says that if civil servants commit a national security offense, the pension can be withheld. To clarify, when a civil servant has retired and already on pension, say this retired civil servant breaches the Prevention of Bribery Ordinance, there's a mechanism for the government to cancel or reduce the pension. Now, the second point is that we're now adding the national security offense into the existing mechanism. So it applies for some offenses but not others. So unlawful demonstration on others, and they're not covered. Mr. Tommy Cheung, you can look at clause 123, amending section 15 of the Pensions Ordinance. It sets out the offenses where the pension can be cancelled or suspended. Mr. Holden Chow, 2 questions for me. So someone is found guilty of national security offenses and then the pension is suspended. But there's a scenario, and that is absconders. Say you have a public officer who is also an absconder. There are measures targeting absconders. Say a retired public officer on pension has absconded, but the conviction has yet to arrive because there is no trial yet. But say this retired public officer has absconded. Can we suspend the pension? The wording now says that the public officer or ex-public officer has to be convicted before the pension can be suspended. So that's my first question. Now my second question. I get the point about the need for conviction. To be fair and proportionate, you need to impose the punishment only after the conviction, but in exceptional cases. In 2019, when we had the Black Clad riots, there were teachers engaging in professional misconduct. After the teachers were arrested, there was a lengthy investigation before a trial could happen. We got public comment, complaints saying that those teachers alleging who are suspected to engage in misconduct continue to teach at schools. I followed up the cases. The government responded. So the rules were changed to protect students from certain teachers. The rules were changed. Teachers with allegations of professional misconduct could no longer teach. Of course, it's not a perfect analogy, but I'm using this as an example to achieve deterrence for grave national security offenses. It will take time before we get to the trial and to the judgment. So can we do something that can provide deterrence for very grave national security offenses? Even before the trial, can we suspend the pension for a public officer in that case? Can we achieve greater deterrence? So you're saying before the trial, but there is a presumption of innocence. Indeed, Chairman, the presumption of innocence applies in normal cases, but I used extreme cases. That's why I cited the example of teachers with allegations of professional misconduct. I'm tossing around the idea, can we get a response? And maybe, has the government considered this possibility? Secretary for Security. Now we're talking about possible scenario A public officer who has yet to retire, say teachers, suspected of professional misconduct, still teaching. Scenario 2, we have already arrested a person. There is a mechanism to suspend a person, that is a civil servant, from duties. And then the government can decide whether to suspend the pay as well. This applies to civil servants who have not retired. Now we come to retired civil servants. For this bill, in specific cases like breaches of the Prevention of Bribery Ordinance or a breach of laws on national security, we can follow the mechanism by withholding or suspending the pay. Now, I come to the third case, absconders. Absconders are not convicted criminals. We can follow Clause 87 of the bill by cutting off funds or preventing the handling of funds, so that absconders will have no access to the money in their account until the absconders come back to Hong Kong. So we do have a mechanism to address that too. Any follow-up questions? Mr. Tony Te speaking for the second round. Thank you, Chairman. We need to strike a balance. So for someone who is not convicted yet, a trial has not happened yet, and assume this is a retired civil servant. This retired civil servant continues to get their pension. Can we suspend that pension? If we can, and the trial happens and the judgment shows that this retired civil servant is not guilty, of course, we should give back to this retired civil servant the pension that is suspended. Are there other ways, other forms of redress for such a retired civil servant? Secretary for Security. Under common law, we have to assume people are innocent until they are proved guilty. So the practice suggested by the member may be at odds with the spirit of common law. So this means someone has to be convicted before we can suspend or cancel someone's pension. So during the trial, the retired civil servant remains on pension. Is that also the current practice? The member is right. We have this practice because under common law, there is the presumption of innocence until someone is found guilty at the court. So that's the presumption of innocence until the defendant is found guilty. Mr. Kitson Yang speaking for the second round. Clause 83. It's about the breach of the movement restriction order. For absconders, they don't have a place to live. They are in breach of Clause 83, and that's in breach of the national security law, a national security offense. We can suspend the pension. Why pay in an absconder? Of course, the absconder can only use the money after they come back, but we're talking about public money. The public money goes into the bank account of the absconder. That's why this is a matter of concern to people. When we prosecute someone under Clause 83, can we already suspend someone's pension on that ground? Clause 83 is about contravention of movement restriction orders. Someone is on bail. We impose this movement restriction order on that person. The person has to be somewhere at a certain time. This is a person who is not an absconder. Oh, he's saying someone who has already absconded. Now, absconders. We haven't prosecuted the absconder yet because this person is at large. We cannot go ahead with sentencing. And again, under common law, until someone is found guilty at the court of law, we cannot impose the restrictions and penalties. Can we get the officials continue to walk us through the clauses? That's Clause 125. Thank you, Chairman. Clause 125. And this is about amending the Pension Benefits Ordinance, Section 29. Pension benefits may be cancelled, suspended, or reduced on conviction. Section 29, subsection 1c, sets out persons who are granted pension, but the pension may be cancelled, suspended, or reduced in certain scenarios. 1c, treason under Section 2 of the Crimes Ordinance. We now propose a corresponding amendment, replacing that with any offense endangering national security. And in that case, the pension benefits may be cancelled, suspended, or reduced on conviction. Thank you, Chairman. Questions? If not, can the officials continue? We go on to Clause 153. Thank you, Chairman. So that's Clause 153, page 239 to 240 of the bundle. This is amending Pension Benefits Judicial Officers Ordinance, Section 31 amended. Pension benefits may be cancelled, suspended, or reduced on conviction. Section 31, subsection 1c. It currently reads treason under Section 2 of the Crimes Ordinance. Our proposed change is to substitute it with an offense endangering national security, and that would be a condition when the pension can be cancelled, suspended, or reduced. Ms. Carmen Khan. I've read through these three clauses. They have to do with the pension for civil servants and judicial officers. Clause 125 and this clause deal with people who are granted pension but then found guilty of national security offenses. Clause 153, amending Section 31, subsection 1c. We see the offenses. The Crimes Ordinance mentions just treason. Back then, the Chinese rendering was 叛逆. Now we're proposing to replace it with 叛國. we're expanding the scope from just treason to any offense endangering national security. And the rest of the mechanism remains in place. I want to make sure I'm reading it right. Thank you.
Your understanding is correct, Ms. Carmen Khan. There being no further question, let's continue. Clause 144, that is Division C. That is in terms of early release of prisoners serving a sentence in respect of a conviction of an offense endangering national security. This is to address the issue where a prisoner on early release continue to engage in activities endangering national security. So I refer you to this division. Now page 183, clause 144, amending the prison rules. Rule 69 amended, remission of sentence. Under the original Section 1 and 2, a prisoner may be granted remission of sentence because of good behavior. Rule 2, the remission period must not exceed 1/3 of the original sentence. Now we are adding brackets 1A, B, and C. Brackets 1A, however, if a prisoner serves a sentence in respect of the prisoner's conviction of an offense endangering national security, the prisoner must not be granted remission under Sub-Rule 1 unless the commissioner, that is the commissioner for the Correctional Services Department, is satisfied that the prisoner's being granted remission will not be contrary to the interest of national security. 1B, to avoid doubt, subsection 1A applies whether the sentence or the prisoner mentioned in that subsection was imposed before, on, or after the commencement of that subsection. 1C, if a prisoner is not granted remission because of a decision made by the commissioner under subsection 1A, the commissioner must, after making the decision, review the decision annually. Question. Reverend Peter Kuhn. Thank you, Chairman. I believe the original intention of granting a remission of sentence is that for incentivizing good behavior and diligence among the prisoners during their prison terms. I agree with the principle, but I have a suggestion on 1C. There is a requirement of an annual review on the decision conducted by the commissioner. I suggest a half-yearly review. It would incentivize the prisoners more. Some prisoners who are close to the end of the term of imprisonment would have no incentives to show good behavior. So on one hand, we want to address national security risk. On the other hand, we want to encourage prisoners to show good behavior and diligence during their prison terms. We want them to be industrious. Concerning the annual review mechanism that applies to every prisoner. So this is modeled upon the review mechanism for ordinary prisoners. Allow me to supplement. The annual review has struck a balance. We would conduct a review whenever there is a change in circumstances. For example, the mentality of the person, the behavioral changes. So it seems that an annual review is appropriate, in particular for national security offenders. It would be reasonable to assess their risk to national security once a year. Mr. Lai Tong Kwok. I have several questions. 1B. Applies to any person in incarceration. So does that have a retrospective effect? Now, a prisoner was looking forward to have been granted remission of sentence of good behavior, but since the bill is passed, the mechanism would no longer apply. And also, the factors to be considered by the Commissioner for Correctional Services. Will the person incarcerated be given an opportunity to make a submission to the Commissioner? 3. If an incarcerated person is aggrieved by the decision made by the Commissioner for Correctional Services, is there an appeal mechanism? Ms. Daphne Siu. Thank you, Chairman. Concerning the remission of sentence under the prison rules, concerning the retrospective effect, well, usually for criminal offenses, there is no retrospective effect. So first of all, this is not a criminal offense. This is just an administrative arrangement. And the material time is the moment when the decision is made by the Commissioner, and also when the incarcerated person is eligible to be considered for a remission. So the premise is the remission cannot be less than 2/3 of the original sentence. That is, if the original sentence is 3 years, the prisoner must have served at least 2 years of imprisonment. So the material time is when the consideration is made whether remission of sentence is granted. After that, there is no retrospective effect. If a remission is granted and the bill is passed, of course, we can't call back the prisoner and imprison him again. Mr. Gary Chen. 2 questions. My first question echoed Reverend Peter Coons. Why a review? Why an annual review? Now, Mr. Chris Tang has been clear. This is modeled upon the existing arrangements. Second question. I'm thinking ahead here. Now, if you look at clause 155, post-release supervision of prisoners ordinance, and also recalling prisoner for sentencing review. So those are biannual mechanisms. And also those are annual mechanisms. So if that is the usual practice in correctional institutions, I will be fine with it. Ms. Daphne Siu. Under the 2 other ordinances, there is a requirement for annual or biannual review. That is the statutory duty of the Commissioner. Now, under the prison rules that is the remission of sentence, that is a discretionary power. Now, an annual review is mandated. But if the Commissioner finds it appropriate, a review can be conducted any time. Ms. Carmen Khan. Now, returning to the legislative brief, paragraph 69, it goes like this. There have been cases in which prisoners convicted of offences endangering national security absconded or continued to carry out acts and activities endangering national security when they were granted early release under supervision. The granting of early release is never a necessary right to prisoners. In order to safeguard national security and protect the public, it is necessary to impose more stringent restrictions on the granting of early release to prisoners involved in offences endangering national security. I invite the authority to explain this part. Now, the spirit of the bill is to respect human rights. So there is no retrospective effect to the criminal offense and the punishments. However, on granting early release, this is not a natural right for the prisoners. Is that right? Ms. Daphne Sue? Yes, Ms. Carmen Khan. Early release is not a rise to the prisoners. Its sentence has been handed down, so 3 years is 3 years. The early release decision is a discretionary power to be exercised by the Commissioner for Correctional Services to incentivize industrious behavior and good behavior. If there are these elements, then the Commissioner may exercise the discretionary power for early release. Under national security offences, there is an additional element, that is, the Commissioner needs to consider whether the early release would undermine national security. So it's like granting bail. For national security cases, the decision on granting bail is whether an accused would continue to pose danger to national security. The design is same here. First, we would look at whether early release would compromise national security. Then the Commissioner can consider whether early release should be granted based on industrious and good behavior. Thank you. That is very clear. So now we understand there is still an early release under supervision arrangement. It's not a right, but this arrangement still exists. If the Commissioner is satisfied that a remission of sentence or early release will not pose danger to national security, that can still happen. Thank you, Mr. Lai Tong-kwok, second round. So I asked 3 questions, which have been answered. Now the remaining 2. When the Commissioner considers the application, will the Commissioner allow the incarcerated person a chance to make submission? And the other question, for aggrieved incarcerated persons, is there an appeal mechanism? Ms. Daphne Sue. The incarcerated person is under the supervision of the Correctional Services Department, so whenever he is aggrieved, an application can be made. There is no restriction to that. An application for leave to appeal on sentence may be submitted at any time at all. So if the application is turned down again, the person can make another application. So it depends on the internal procedures and arrangements of the Correctional Services Department. Anyway, there is no time limit. During the incarceration period, the incarcerated person may submit any submission to the Commissioner, and the decision is subject to judicial review. Let's continue. Clause 155. Thank you. Please refer to page 198. Clause 155, Amendment to Post-Release Supervision of Prisoners Ordinance, Section 6. Early release under supervision may be granted by the Board. Now, brackets 1, the Board, based on industrious and good behavior, if the Board considers it appropriate to grant early release under supervision, the Board may grant such a release. We propose adding 3A, B, and C. The policy is the same as the previous clause. If a prisoner serves a sentence in respect of the prisoner's conviction of an offense endangering national security, the Commissioner must not refer to the Board for its consideration under subsection 3 the case of the prisoner unless the Commissioner is satisfied that the prisoner will not be contrary to the interests of national security. 3B. Whether the sentence of the prisoner mentioned in that subsection was imposed before or thereafter the commencement of that subsection, subsection 3A still applies. If the Commissioner decides under subsection 3A not to refer to the Board for its consideration the case of the prisoner, the Commissioner must, after making the decision, review the decision annually.
Questions? If not, we move on. Clause 156, please. Thank you, Chairman. Clause 156. Amendment to Post-Release Supervision of Prisoners Regulation. Schedule 1. Under the specified offenses, we add an offense endangering national security. So that will be page 246 of the bundle. Thank you, Chairman. Questions? If not, Clause 168. Thank you, Chairman. Now, Clause 168 is about amendments to long-term prison sentences review ordinance, Section 11, adding 1A, 1B, and 1C. 1A. If a prisoner serves a sentence in respect of the prisoner's conviction of an offense endangering national security, the Commissioner of Correctional Services, that is, must not refer to the board for review the sentence the prisoner under this section unless the Commissioner is satisfied that an early release of the prisoner will not be contrary to the interests of national security. 1B. Whether the sentence was handed down before or no after the commencement of that subsection, this subsection applies. And 1C, if the Commissioner decides not to refer the case to the board for review, the Commissioner must, after making the decision, review the decision every 2 years. Questions? Ms. Carmen Khan. Chairman, can I clarify a point? Why a review every 2 years? We discussed annual reviews, but here it's every 2 years. And can we get the full name of this board? Ms. Stephanie Siu. Now, we set it at 2 years because the ordinance has this existing rule of a review every 2 years of the relevant board. That's Cap 524, the Long-Term Prison Sentences Review Ordinance. The board is the Long-Term Prison Sentences Review Board. Section 5 sets out the full name of the board. Thank you. No follow-up. Mr. Holden Chow. Thank you, Chairman. Can I find out more about this long-term prison sentences review arrangement? The board reviews decisions every 2 years. We were talking about an annual review. So for sentence review, one review is for long-term prison review, whereas the other review covers non-long-term prison sentences. Is that the case? Ms. Stephanie Siu, correct. Those two reviews look at different sentences. One review looks at longer sentences, whereas the other review board looks at the offenses under the schedule. There's a schedule that sets out the specified offenses to which that board will refer to. No other questions? We continue. Clause 169. Thank you, Chairman. Amending Section 28. Review of sentence after recall. We add 3 subsections. Section 28, subsection 2, if a prisoner serves a sentence in respect of a national security offense, the Commissioner, that is, of Correctional Services, must not refer the sentence to the board for review unless the Commissioner is satisfied that an early release of the prisoner will not be contrary to the interests of national security. Again, the board is the Long-Term Prison Sentences Review Board. Subclause 3, to avoid doubt, subsection 2 applies whether the sentence was imposed before, on, or after the commencement of that subsection. Subclause 4. If the Commissioner decides under subsection 2 not to refer the sentence to the board for review, the Commissioner must, after making the decision, review the decision every 2 years. Thank you, Chairman. Questions? If not, please continue. We come to Part D, Thank you, Chairman. And this part has to do with the disqualification under election laws in relation to national security offenses. First, Clause 170, and that's page 287 of the bundle. This is amendment to Legislative Council Ordinance, Section 39. When a person is disqualified from being nominated as a candidate and from being elected as a member. Section 29, subsection 1, bracket C. The old provision or the current provision has been convicted of treason. We propose amending it by making it has been convicted of an offense endangering national security. We have a whole series of amendments to give effect to Article 35 of the National Security Law. That anyone convicted of national security offenses will not qualify for an election, that is standing as a candidate or otherwise. Thank you, Chairman. Questions? If not, we come to Clause 171. Thank you, Chairman. Clause 171, amending Section 40. What requirements are to be complied with by persons nominated as candidates? 40, subsection 40, subsection 1, Roman numeral 3, C, item C, replacing being convicted of treason with being convicted of an offense endangering national security. Thank you, Chairman. No questions. We come to Part 9, Division 26. That's Clause 172. Thank you, Chairman. Clause 172. Amend Section 14 of the District Council's Ordinance. This is about disqualification from being appointed as members. We propose amending Section 14, subsection 1c, replacing has been convicted of treason with has been convicted of an offense endangering national security. Thank you, Chairman. There are no questions. Clause 173, please. Clause 173 amends Section 19, disqualification from being registered as ex officio members. We propose amending C under subsection 1 of Section 19 has been convicted of treason to be replaced with has been convicted of an offense endangering national security. Thank you, Chairman. No questions. Moving on. Clause 174. Thank you, Chairman. This amends Section 21. When a person is disqualified from being nominated as a candidate and from being elected as a member, we propose amending Section 21, subsection 1c. Has been convicted of treason to be replaced with has been convicted of an offense endangering national security. Thank you, Chairman. No questions. Please move on. Clause 175. Clause 175 amends Section 26A, disqualification from holding office as members. We propose amending Section 26A, subsection 1c, has been convicted of treason to be replaced with an offense endangering national security. Thank you, Chairman. Mr. Holden Chow. Chairman, we have covered clauses that replace treason with national security offenses. Can I confirm whether I'm getting this right? To serve in these public offices, Clause 171 all the way to 175, they refer to electoral members, candidates for electoral members, or district councillors, and that includes appointed members. The existing law is that you have to have a sentence at 3 months or longer before you can bar someone from taking the public office. But here the change is that when someone is convicted of any national security offense, the provision applies. So here's a scenario. Say someone commits a national security offense, of course, that's serious. And even if the sentence is less than 3 months, I know it's rare, but what if this happens under the new system? Even if the sentence is less than 3 months, given the new arrangement, that is, this person is convicted of a national security offense, this person cannot serve in a public office. I want to confirm this is the case. Is this the case under the bill? Now we give effect to Article 35 of the National Security Law. That article under the NSL does not make a distinction based on the length of sentence. Article 35 of the NSL says anyone found guilty at the court for national security offenses will be barred from serving as a councillor or standing as a candidate. So we are giving effect to Article 35 of the NSL. So I'm just confirming I'm reading that right. Got it. Thank you. I have a question. This is about being disqualified. Does that disqualification kick in right away? Does the matter have to go through a legislative procedure? Does legislature have to pass a motion with a certain number of members present? So we can skip those procedures. The disqualification kicks in instantly. Is that the case? Yes, that's how we read it. So the point is automatically. This happens automatically. So legislature doesn't have to do anything when that happens. Ms. Stephanie Seal. The clauses are in line with Article 35 of the NSL, and that is instant disqualification. Got it. Thank you. If there are no other questions, we move on. Clause 176, Division 27. Clause 176, amending the Chief Executive Election Ordinance, amending Section 14, disqualification from being nominated. We propose amending Section 14, 1G, and treason to be replaced with an offense endangering national security. Thank you, Chairman. No questions. Clause 177, please. Thank you. Clause 177 amends Section 16, manner of nomination. Members can refer to page 307, Section 16, 5C, paragraph A, B, C, etc. of the schedule. We propose inserting CA. You will see what CA is as we move along. Thank you. No questions. Clause 178. Thank you, Chairman. Clause 178 amends the schedule. It's about the election committee. Page 310 of the bundle. 5M. When a person is disqualified from being registered as an ex officio member, under subsection 1, we propose inserting AB, that is, has been convicted of an offense endangering national security. Moving along. Amending section 9 on page 312 in the bundle. When a person is disqualified from being a nominee, under subsection 1 of section 9, we insert AB has been convicted of an offense endangering national security. We come to the next part, section 18. When a person is disqualified from being a subsector candidate, we propose inserting CA. So that's something we mentioned in the previous amendment. CA reads has been convicted of an offense endangering national security. Thank you, Chairman. Questions? No. Division 28, the Rural Representative Election Ordinance, Cap 576, Clause 179.
Thank you, Chairman. Clause 179, amendments to Rural Representative Election Ordinance. Section 9, amended when a rural representative is disqualified from holding office. we are proposing to repeal treason in section 9 brackets 1c and substitute the phrase by an offence endangering national security. Deputy Secretary, we mentioned Article 35 of the Hong Kong NSL. Article 35 gave no particular mentioning to the disqualification of a rural representative. However, for other level of elections, people convicted with national security offences would be disqualified from holding office. So we decide to apply the same to rural representative. If there's no question, clause 180. Thank you, Chairman. Amending section 23. When the person is disqualified from being nominated as a candidate and from being elected as a rural representative. Under subsection 23 brackets 1c, we are substituting the reference to treason with an offence endangering national security. Thank you. Ms. Carmen Can. Thank you, Chairman. So we are now past Part D. So this is about changing the references in other laws in terms of the Safeguarding National Security Ordinance. Now, under Article 35 of the Hong Kong NSL, since its introduction on the 30th of June in 2020, it is only now that we are taking up the responsibility imposed on us under Article 35 of the Hong Kong NSL. So have we fulfilled all our responsibilities under Article 33 of the Hong Kong NSL? Official, Deputy Secretary. All relevant obligations under Article 35 have been completed, subject to the passage of this bill. Chairman, the Deputy Secretary mentioned that disqualification of rural representative has not been mentioned in Article 35 of Hong Kong NSL, but it has an impact on the composition of district councils because ex-official members will be returned among rural representatives. So you are applying the change to this ordinance as well. Correct. There being no further question, we go back to Part 20, Clause 154. Amendments to Hong Kong Arts Development Council Ordinance, Section 3, Establishments of the Council. So please I refer you to page 197. We propose to amend Section 36M, substituting the reference of treason with any offence endangering national security. Now, Section 6A to M. So these are persons appointed by the Chief Executive as the Chairman, Vice Chairman, and members of the Hong Kong Arts Development Council. So is that permanent for a person convicted of national security offences? Will the disqualification be permanent, or is there a limit? I mean the time during which the Chief Executive cannot appoint the person as a member of the council. So I refer you to the text. So there is a series of offense. And anyone convicted of national security offenses, there is no mentioning of the time. But if you refer to L, for certain offenses, there is a time limit. So it seems that the difference between M and L is that for M, it carries a permanent effect, since there is no mentioning of a time limit. For other subsections, there is the mentioning of a time limit, but not in M. Thank you. Any other question? Ms. Carmen Khan. Thank you. Now, E, persons convicted of national security offenses and are rendered ineligible to take public offices. So I wonder why we are dealing with the eligibility of Hong Kong Arts Development Council members under Clause 154. Why are we not amending the other ordinances as well? I know Mr. Gary Chen also wants to ask this question. Deputy Secretary, Clause 154 and the subsequent clauses are similar amendments. We are proposing these amendments because after drafting the law, we have taken a look at similar references made in other ordinances. We have singled out these few ordinances because there are the mentioning of treason in these ordinances. For those who have been convicted of treason, they can't take up certain positions. So we are applying the same concept here. So treason was a very serious offense. So concerning whether we can allow persons convicted of treason take up public offices, some considerations will have to be made. For example, at the Film Censorship Office, there is also the consideration of national security factors. So we are substituting the reference of treason with any offense endangering national security, and we think this is appropriate in this context. It aligns with the overall policy of the government to safeguarding national security. Carmen Khan. Now, if Mr. Gary Chen has the same question with me, I invite him to supplement me. My question is, why just Hong Kong Arts Development Council? So you said you have reviewed all the same references in other ordinances. I'm just worried that you have missed out something. So like in Part 8 and Part 9, there were a general reference to anyone holding a public office. So like we said before, the composition of the situations may change. So if there is a more general reference, it may be more effective. So I think this is about the policy of the government. So may I invite the government to respond? We will take note of the members' suggestion and consider it. Mr. Holden Chow, my question is the same. It has been covered by Ms. Carmen Khan. Thank you. Mr. Jeffrey Lam. Please switch on Mr. Jeffrey Lam's mic. Section 3, 6, the following persons are not eligible for appointment by the chief executive, and so on, so on. So the chief executive is the gatekeeper. The chief executive will not appoint these persons to any public office. So if you are saying that they are not eligible for appointment by the C, is that superfluous? So we can consider that every public office will not be eligible to be taken by these convicted persons. I agree with you, Deputy Secretary. If the chief executive would like to appoint a convicted person, convicted of national security offense, then I think everyone will have an issue with that. That's my interpretation. Dr. Lo Wai Kwok, why do we make specific referencing to Hong Kong Arts Development Council? Because the membership of this council is special. There is a nomination and election process. So the previous clauses are related to elections. So the same applies for the Arts Development Council. For persons convicted of national security offenses, they will not be eligible for nomination or candidacy. So I think the situation for Arts Development Council is the same. For seats appointed by the government, we don't have to mention them, like the board of the airport authority and so on. Is my understanding correct? That is because of the historical offense of treason. That's why we are changing the reference to offense endangering national security. So the history, concerning the history, the historical factors, and why just Arts Development Council, we need to review it after the meeting. Mrs. Regina Ip, just now some colleagues mentioned whether we need to add a catch-all provision. But doesn't Clause 107 serve that purpose? Clause 107, the chief executive may issue an administrative instruction in connection with safeguarding national security. If there is a problematic appointment, the chief executive simply has to issue an administrative instructions. We don't need a catch-all provision. Now, I may extend the duration of this meeting until this question has been answered, if necessary. Secretary, Clause 107 mentioned by Mrs. Regina Ip, that may serve as a catch-all provision. We will study it after the meeting. Thank you. Any other questions concerning this particular clause? There being no question, Item 1 is concluded. Item 2, several matters. We are coming to the close of the clause-by-clause scrutiny. I invite government officials and the Secretariat to check once again whether we have missed any clause. If so, we will come back to them in the next meeting. I invite the officials and the Secretariat to do the same. Second, some members told me that they would like to come back to some important issues in previous clauses. I don't know how many of them wants to do so, but I will handle it with discretion. If you wish to do so, please tell the deputy chairman concerning the clauses you want to go back to. 3, in the next session, I'm going to invite the legal advisor to raise any questions relevant to the entire bill. Mrs. Regina Ip, I would like to go back to some clauses. I've submitted suggestions to change some terms to the DOJ and just like CSA proposals. So maybe during the CSA study, we can discuss that. For other questions, if necessary, please submit them to the Deputy Chairman. Thank you. The next meeting is scheduled at 2:30 p.m. today. Meeting is adjourned. Thank you.